time right now, the timing of this case, of his particular facts, and the timing of other matters before the court. It is going to be our argument that what has happened legislatively has created a sea change in ex post facto law, and it relates to this case. We will get to some of the timing in that because it's important as well, because other death cases are pending with this court. And we've reviewed Michael Jackson, for example, argued last fall. We reviewed Zeiler. We reviewed McDowell. Those have raised this issue, touched upon it, but arguments have not focused on it to the extent that I will today, hopefully, in an effort to persuade the court to see the impact of Section 775.022.
All right, welcome back to the Bench Breakdown. Today we're looking at a Florida Supreme Court argument in a death penalty case where the entire dispute centers on one issue. Did the legislature change the rule after the crime? Does that violate the ex post facto protections? You're going to hear the defense argue that the 2019 statutory change reshaped how the ex post facto law works in Florida, and the justice puts back hard, questioning whether this argument is even legally viable. Let's break it down.
On our ex post facto law, we will argue that, in fact, it vitiates much of the decisional, general, constitutional ex post facto law. And the reason for the time frame being so important here is, let's start with what happened. The murder here, which I agreed, acknowledged, is an ugly murder, and there's no escaping that fact, and my client pled guilty. But the murder occurred in December 2019. 2019 was a very important year to the structure of this. I need to go back before it, and I need to follow up after it. December of 2019, this act took place. 6 months earlier, the legislature enacted for the first time a new statute, 775.022. I'll come back to it. It refers to Article 10, Section 9 of the state constitution. That is referred to as the Savings Clause. Article 10 is titled miscellaneous. It's the things that are important, but they didn't get in the first 9 sections. Article 10, Section 9, the Savings Clause, was amended effective January 8 of 2019, almost a year before this case took place, as a result of constitutional revision committee. What happened with Article 10, Section 9, that's a savings clause. What it was meant to do, and in case I forget to say so, what it was meant to do simply was say you don't get away with it. If you commit an act on this date, and on that date, that act is an offense, a crime, and it bears a certain punishment, and that statute is later repealed or amended, you don't get away with it. You are held to the statute as it took place at that time. Now, that revision of Article 10, Section 9, the prior language said, repeal or amendment of a criminal statute shall not affect prosecution or punishment for any crime previously committed. The amendment changed that language. It removed or amendment, and it removed or punishment. It now reads, repeal of a criminal statute shall not affect prosecution for any crime committed before such repeal. They took out amendment. They took out things. So what happened when this became effective in January of 2019, the legislature got to work in that session. And by June of 2019, again, predating my client's case, in June of 2019, the legislature enacted 775.022, which we argue is ex post facto.
Okay, let's pause right here. He is shifting from the constitutional change in 2019 to the legislative response. This is important because it sets up his entire ex post facto argument. The legislature knew exactly what it was doing when it rewrote the sentencing statute months before the crime happened.
It goes to Article 1, Section 10, our important part of the Florida Constitution that says no bill of attainder, ex post facto law, or law impairing the obligations of contract shall be passed. That's the constitutional concept underlying the same as the federal Constitution. And we have relied on that for all of our nuances of interpretation of that to determine ex post facto. Now, however, the legislature has told us what ex post facto is. And specifically, when I address 775.022, the first paragraph is the intent of the legislature that, and subsection A says, the section will preclude the application of common law doctrine of abatement to reenactment or amendment of a criminal statute, and that an act of the legislature reenacting or amending the criminal statute not be considered a repeal or implied repeal of such statute for the purposes of Section 9 of Article 10, as we discussed. So that's where it's related to the savings clause, and unfortunately, the state in their brief and others have referred to this as a savings statute. It is not at all limited to the savings statute. By the legislature's own language, they have expanded greatly into ex post facto under Article 1, Section 10. Specifically, Section 2 says, as used in this section, the term, quote, criminal statute, close quote, means a statute, whether substantive or procedural, dealing in any way with a crime or its punishment, defining a crime or defense to a crime, or providing the punishment for a crime. That's what it applies to. Then it says 3, except as expressly provided in an act of the legislature or as provided in 4 and 5 below, the reenactment or amendment of a criminal statute operates prospectively and does not affect or abate any of the following: A, the prior operation of the statute or prosecution or enforcement thereunder; B, violation of the statute based on any act or omission occurring before the effective date of the act; and C, a prior penalty, prior forfeiture, or prior punishment incurred or imposed under the statute. In short, my argument is that this section applies to my client because it was enacted before his case took place.
Haven't we rejected this before?
Pardon?
Haven't we rejected your argument before?
This is the moment where the court really leans in. You can hear the justice basically saying, haven't we already dealt with this argument? And that's an important challenge, because in appellate law, if the issue has already been decided, the court isn't going to reopen it unless something fundamentally has changed.
I'm trying to state it in a slightly different way in an effort to persuade the court.
That sounds sort of like a yes.
Well, I haven't seen it in writing, because I don't believe, unless Westlaw misled me, I don't believe this court has written on this subject in death penalty context. In fact, the opinions issued are lower court opinions not related to death penalty. When it comes to 775.022, explaining its ex post facto relationship. So
I guess my question is, haven't we, first of all, held pretty clearly that all of the changes you're talking about are procedural in nature and not substantive?
Well, yeah, that's the problem, Justice.
Okay, so if you agree with me that we've held that, right, then it would seem to me that we've also then rejected the argument that an ex post facto analysis applies because the Constitution of the state and the U.S. Constitution don't guarantee any recommendation at all by the jury. So just as a matter of first principle, it would seem to me like this argument doesn't really get off the ground because we've pretty clearly and repeatedly held that all of these changes are non-substantive, don't expand the field of punishment, don't increase the penalty, are procedural in giving effect to a regime that narrows the class of persons eligible for the death penalty in the way the legislature has the power to do. So it would seem to me like all of the argument you've just made is kind of already foreclosed by precedent. Help me if I'm not seeing what you're seeing.
Much of the precedent that Your Honor is relying upon, and much of the arguments to date, and that's the importance of this distinction, have been premised on ex post facto law generally. And I am not addressing the general because an important thing you just mentioned, the difference between substantive and procedural. We've gotten into quagmires and gray areas and lines and blurs of substantive versus procedural. However, there had not been until this time a legislative pronouncement that a statute, whether substantive or procedural, dealing in any way with a crime or its punishment. Now that changes the game. That is what I'm talking about. And that is why this is important in this time. During this time, my client was also, and I didn't say earlier, was subject to the previous section of statute 921.141(2)(c), which was at his time unanimity pursuant to Hearst. This is to remember, the event took place December 2019. This is post-Hearst and pre-Poole. So that is his law, and under 921.141(2)(c), he was entitled to a unanimous jury recommendation as a requirement before death could be imposed. This wasn't an override thing. This wasn't a split opinion of 8-4 or any supermajority. Here, his 10-2 was a result of the change only in the statute that occurred subsequent to Poole and in 2023.
Doesn't your argument necessarily depend on your characterization of this as a retroactive application, though? So in other words, right. So, and I mean, the issue is whether or not it's truly a retroactive application. The argument is that because this is a procedural statute, that it wasn't applied retroactively because the date of conviction isn't the operative date from an application perspective. It's when the jury was impaneled, essentially. So don't you still need to get around the kind of substance versus procedure precedent framework in order to make your argument that it's a truly retroactive application?
In a sense, no, and I'll suggest why, although there may be more to the answer to your question. It's an interesting one. The point here, and the reason I reviewed all of that statutory language back in 2019, was that the legislature had knowledge of this and awareness of their own actions for over 3 years before 2023, when they then, in response to Poole of 2000, eventually amended, and it says here they amended 921.141(2)(c) to eviscerate unanimity, pull the rug out from under that, and impose the 8-4 majority.
You know, because I'm looking at 775.022, which is that's the thrust of your argument, correct?
Correct.
And I'm looking at that, and the focus of that is on the prior operation of the statute or a prosecution or enforcement thereunder, or a prior penalty or prior punishment incurred or imposed under the statute. There's some things that have happened, not things that will happen in the future. And again, this is exactly the point, the same point that's been made, but the text here is pointing in the direction of the legislature's desire not to disrupt things that have occurred. If I'm reading that correctly, and I think you're reading into the definition of criminal statute something that goes earlier in this section, something that goes beyond the actual operative provisions of what the statute says it's attempting to do. Tell me why I'm wrong.
Well, Justice, respectfully, I believe that section 921.141 sentence is a criminal statute, and that
But again, it's about the prior. This statute is addressing the prior operation, and in your case, it's not a prior operation. It's something that's happening in the future.
the prior operation is, I would argue, related to the word act as cited in the statute. It goes back to the act, the date of the act, and that is in subsection, pardon me one moment.
So tell me what part of, in 775.022, what part of subsection 3 covers the situation here?
All right, let's pause again for a second. Now, we're deep in the statutory interpretation phase. You can hear the justice drilling into the exact language of the subsection 3, and he's pushing him to explain where his argument actually fits in this statute itself.
Well, I believe all of it does, but to try to be more specific, 3B says a violation of the statute based on any act or omission occurring before the effective date of the act. Now, the effective date of the act I'm concerned about is the later revision that is being applied retroactively. My point was about to be that in 2023, the legislature knew its laws here.
It's talking about a violation of a statute. It's not talking about some procedural provisions of a statute. This is talking about a violation. When it says violation here, it's talking about an offense, I believe. And wouldn't that be the ordinary way to understand that?
I believe if we read it all, the entire section in paramateria, what we're going to find is that it is whether substantive or procedural, dealing in any way with a crime or its punishment. And we argue that sentencing is a statute dealing with punishment. So,
I'm sorry to interrupt you, but haven't we held basically that, put aside substance and procedure, when you're talking about just whether something is being applied retroactively or not, the basic question that we ask is, what is the thing that is being regulated? And whether it's conduct or procedure, and if it hasn't happened yet, when the statute that you're trying to apply is going to be the one that governs it, then we don't consider that retroactive. And so in this case, the sentencing proceeding, as Justice Sasso and Justice Kennedy have said, it hadn't happened yet, and so it's not being applied retroactively. And so you don't need to get bogged down in substance, procedure, et cetera. If that's what's being regulated, then sort of by definition, it's not retrospective because it had not occurred yet at the time that the new operative provision came into effect.
well, yes, Chief Justice, we also respectfully argue that the statute, the death penalty as a whole, was something that was in place at that time.
All right, we'll leave it right there. If you want the next part of this case, or if there's another argument you want me to break down from the Florida Supreme Court or any other state, just drop it in the comments. Thank you for watching Bench Breakdown. I'll see you on the next one.